I wore a special tie to look very judicial when we talk about the court systems. So we're going to talk about the federal judiciary. That's to say the branch that deals with justice. And, the founders thought about this as the least dangerous branch. In fact, they didn't even pay very much attention to it in the Constitution. They just sort of said, we're going to need a court system. And the court system is going to deal with how people work out conflicts. And so they assumed it was going to be the weakest branch, which doesn't actually work that way now. It describes the power of the judiciary, and really interestingly, it doesn't ever give power to the federal judiciary to oversee the acts of Congress or the president. That was actually a great story, which you should read about in the book, but it deals with Marbury versus Madison. Anyway, the Supreme Court, the federal Supreme Court, is the highest court in all the land. It settles all the disputes ultimately. The creation of all the lower courts was left to Congress. So Congress could structure the court system in the federal government however they wanted to do it. And they could limit or expand the number of judges and how the appeals court process worked and all that stuff as well. Remember, from the founding, the states have a state court system, and the federal government has a federal court system, and the Constitution is all we're talking about with the federal court system. The Constitution describes the Supreme Court's jurisdiction as original jurisdiction and appellate jurisdiction. Original jurisdiction means that that's the first time a case is heard before a court. And there are some things in which the federal government, the Supreme Court can hear a case for the first time. The vast majority of the time, though, it's an appeals court. It's an appeals court, and an appeals court just verifies that the previous courts have ruled properly on what was presented to them. So the Anti-Federalists were really, going back in time, the Anti-Federalists were really worried about the court being super powerful and abusing individual liberties. And even Alexander Hamilton in Federal 78 said, the courts would be above politics, they won't be partisan, they'll be weak, we won't have to really worry about them, we'll let Congress deal with all that stuff. So the Congress create these lower courts in 1789, and they create the power of the Attorney General. The Attorney General now leads the Justice Department, but that person is an appointed person, and they prosecute crimes against the federal government. Now, in Marbury versus Madison, you don't need to I'm not going to tell you the whole story, you can read about it in the book. But essentially, the Justice of the Supreme Court argued that the Supreme Court has the right to review all the acts of Congress and make sure that they were acting within their power. Now, essentially what happened in that ruling was the courts gave themselves power to interpret the Constitution. Now, you wouldn't think that's a big deal, but that's essentially what the Supreme Court does now. They interpret how the Constitution applies to laws and whether or not those laws conform to the requirements of the Constitution. So all this started back essentially with one Supreme Court case. Now, why is that a big deal? Well, the Supreme Court actually tends to follow its previous rulings and the rulings of other courts. That's called stare decisis. It means let the decision stand. So as we let a decision stand, we build upon all the precedents of previous cases. And the precedents are really, really, really important. Okay. The court system is adversarial. One person has to bring a claim against another person. The plaintiff brings the claim and the defendant argues against it. There's state judiciaries and there's national judiciaries, as I've talked about. Now, here's the thing. A state court only deals with state laws. A federal court deals with federal laws, right? Well, also, a federal court can deal with a disagreement between the states or a state law that violates a federal citizen of their federal rights. Okay, now each level of courts deals with civil and criminal cases. A criminal case deals with harm to the community and the violation of a specific law. Most of these end up in a plea bargain. They're not prosecuted. In a criminal case, that's the only way that you can incarcerate somebody or put them in jail. Now, a civil case deals with private rights and relationships between groups and individuals. Now, the civil case can be brought for anybody for any reason. It doesn't have to necessarily be a violation of a law. You could be tried for a criminal case and for a civil case. A criminal case is always brought by the government against an individual, and a civil case can be brought versus anybody. State courts handle the vast majority of all cases. They do the vast majority of the work. Each state has an appeals process where if you don't like the ruling, you can appeal it to the next level up, because the argument is that the court in which you presented, or you had original jurisdiction where you presented that original argument, they didn't rule properly. They violated some standard. It's not that you just don't like their decision, but they actually did something wrong in their decision making. So you can appeal those things up to the state Supreme Court. Some lawsuits begin in state court and end up eventually in a federal court, but in order for it to jump from a state court to a federal court, you have to prove that some federal right or federal law was violated. So really what happens is we have this sort of two-process system. Let me just switch over to it. So it's possible for you to start a case in a state court, and in that state court, you hear a ruling. There are lower or appellate state courts, and maybe you appeal it all the way to the state Supreme Court. If there's a federal issue at stake, you can appeal directly to the states or to the U.S. Supreme Court. It can go to a federal court of appeals. The federal district courts hear federal violations of law or federal laws. If they don't like the rulings, they appeal to a federal appellate court, and they could appeal all the way to the Supreme Court. State courts are established by state constitution and by the U.S. Constitution, but the federal court system is established by the U.S. Constitution. Let me go back. All right. We talked about this, that there is a federal district court, court of appeals, and Supreme Court. We can move on. The states vary, interestingly, in how they select judges. Some states elect their judges. Some states give their judges lifetime appointments. Some of them have a short period of appointment. Some of them can be recalled. They can be pulled out of office. But all federal judges are nominated by the president and confirmed by the Senate. So in other words, the president gets to select who are going to be these federal judges, and the senators have to agree to that. The district court nominees are generally accepted, but by the time we get to appeals courts and Supreme Courts, the appointment of these justices is very contentious because they now have a record of how they've been ruling. Now, this is something that's really difficult for most people to understand. Justices are not supposed to be partisan. That's to say, they're not supposed to be of a specific party affiliation. But they do have an ideology. And that ideology, or the things that they think are important and how they should rule on those things, are generally manifest in the decisions that they've made before. So as a president starts to select an individual to serve on a court, they look at their judicial ideology. And a senator cannot restrict a qualified judge from serving based solely on ideology. There's actually no constitutional requirements to serve in the federal judiciary, but most of the time what happens is they look at experience, integrity, and legal accomplishments of those people who've been selected to serve in the federal judiciary. Like I said, presidents tend to nominate individuals who share their same ideology and preferences, so you tend to find Republican presidents appointing conservative justices to the courts, and you'd find Democratic presidents generally appointing more liberal justices to the court system. And we don't actually know how they'll behave. Actually, once they're appointed to the Supreme Court, for example, we can only guess based on what they've ruled on previously. So most senators, when they go through this process to try and confirm judges, they're trying to pick apart and figure out what those justices are going to do. For example, over a contentious issue like Roe versus Wade in abortion. Now, justices have learned very wisely to skirt those issues and say, well, I wouldn't know because I really just rule upon the issue at hand. I don't predispose myself to ruling a specific way. Now, I think that's pretty smart because judges are supposed to rule on the merits of a case, not on what they believe a case should be. So that's there's no guarantee. Even some conservative presidents have appointed conservative judges, and they've flip-flopped a little bit. Okay, so going back to criminal versus civil law, criminal law violates a law, and the possibility is that you can be incarcerated. In order to be convicted of a criminal law, you have to be convicted. A jury has to believe beyond a reasonable doubt that you violated the law. In a civil law, two people are in an adversarial relationship. They're trying to figure out who's right. Most of the time, this involves money. And the standard for this, for being proven guilty, is the propensity of evidence. That's to say, there just seems to be more evidence that an individual did it than the other. So we talked about original jurisdiction in the federal judiciary. Original jurisdiction is where, at least in the federal system, where the federal government is taking a lawsuit against an individual. There's all sorts of things that pertain to that, but importantly enough, it's that they're dealing with a federal question. In other words, the federal government is going against an individual because they violated a federal law or there's a federal issue at stake. Now, appeals courts can hear rulings. They can hear cases in which this evidence has already been entered in an original jurisdiction. The appellate court cases are generally revolve around whether or not the previous court ruled properly, or they went through the right decision-making process to ensure that the decision was fair. It's not as if you get a bad ruling and you start just shopping it around to wherever. When it comes to the Supreme Court, they hear very, very few cases. Like less than 1% of all of the cases that come before them, they agree to hear. They hear almost everything in terms of an appeal. They almost very, very, very rarely hear original evidence. The way that they choose in which cases to hear is called the rule of four, that 4 of the justices have to agree. And then they have to write what's called a writ of certiorari, which is that they agree to hear the case. Part of the things that help them decide are whether or not the court case deals with a relevant or pressing issue. They try to figure out if there's some ambiguity in how the law is being implemented, or if different judges have ruled in different ways. So we have a district court at a federal level, in the West or in the East. They might rule on different things because the judges who are appointed there have different ideologies. And the Supreme Court might take on a case just to sort out how the law should actually be interpreted. Now, those people who petition the court for the federal government, they're called a solicitor general. When a case becomes before the Supreme Court tries to figure out what precedents have come before it. They ask the petitioners to write briefs. That's to say why this case is important, and they ask for friends of the court briefs. They're called amicus curiae briefs. They're given when they have an oral argument, the petitioners come for 30 minutes, and the court gets to ask them all sorts of questions. A couple months later, the court makes their decision in writing. Then the writing occurs a couple different ways. They have a majority opinion, the one who wins, and they often have a minority opinion, why they disagree with why they made a certain decision. And some of these minority and majority decisions end up opening questions or expanding ideas that could be eventually fought out in the future. For example, we could have a firearms lawsuit about what's a reasonable restriction on a firearm. And early on, some of those were like, well, we can't have machine guns just floating around fully automatic. And even though the case didn't really deal with machine guns, they said, oh, well, I wonder what a machine gun actually looks like. And so subsequent cases have defined what the limits of regulating firearms are. So some of these opinions end up leading to either solving or opening new legal questions. Okay. There's some questions about how judges make decisions, and we talk about judicial restraint and judicial activism. Most people are concerned with how judges make decisions. When someone exercises judicial restraint, it means that they try to strictly follow what the law says. An activist judge tries to interpret that law or the words of the Constitution for now, and tries to figure out how that would apply today. So judges who aren't elected have a lot of freedom to interpret how the Constitution or how that law is interpreted forever, because they don't ever have to face an election. They may overturn the actions of an elected branch. Interestingly, unbiased legal decisions are really difficult to come to, if not impossible. So we have different ways in which we think about how judges make decisions. Some of them are just strictly legal. These are called the legal model. They're based on precedent. This is exactly what's been said before. Other times courts have said, well, justices should have the ability to think about what their attitudes are and apply their own attitudes on how we interpret laws. And the last one is to think about how strategically judges make decisions that will lead other institutions like Congress or the president to act in different ways. So that's called the strategic model. Now, like I talked about before, a judicial restraint is the court should maybe just use judicial review to just think about how strictly the law should be interpreted, or how the Constitution should be interpreted, and give the ability to other agencies like the elected branches to really work that out. Judicial activism is the idea that justices should overturn laws when they need to in order to correct mistakes from other branches or to protect individual rights. In other words, to expand how that law is used now, or how it should apply now. The court can be a national policymaker and agenda setter, and it has lots of powerful checks in terms of its processes, how people get appointed, and what influences it, like including public opinion.